Hi, I'm Janice Switlo, and in previous episodes I've emphasized my concern about a large amount of money being dangled and with the promise of it being transferred to the sole control of Chief and Council with no checks and balances. Canada, the Government of Canada is offering this if the Chief and Council are successful in getting a land code in place. Now, it's not often that the law itself is called a land code. It's usually titled with the use of the Indigenous language, but it is, regardless of how it's titled, it is passed for purposes of the First Nation Land Management Act. Being once that is voted in, and most members are simply thinking, oh, this is kind of more, it's just a land use planning exercise under our law. Well, it couldn't be anything further from the truth. It's actually a lot more than that. I'm not going to get into the First Nation Land Management Act here today again. But my point is to emphasize that once those monies are transferred out of trust into the bank account of Chief and Council, with no reporting requirements, no protections insisted upon by Canada that those collective assets are properly governed as such, and no preventative measures of diverting any efforts to have those collective assets converted into the private holdings. What I want to emphasize here is that, and I get a lot of people getting in touch with me about issues and, they want to go to court and all this sort of stuff. And it's like, well, that's all well and good, but how, right? It takes money to go to court. And even if you do go to Canadian courts, you have to appreciate the bias that is in place. Canada wants these systems to work to control the people. And so if individuals are trying to come forward and challenge the activities of Chief and Council, remember these Superior Court judges are appointed and hand-selected by the Canadian government. So I'm pointing out and sharing with you, this is an article from last year, May 17, 2019, that was published in the Vancouver Sun, called Law Must Deal with Digital Era or Else. Legal profession is stuck in the past and needs to change how it does business, experts warn. And this was reporting on occasion of a speaker, Gillian Hadfield, who's an expert in certain areas, been to Stanford, things like that. Her warnings about, and others that I will quote here. So Hadfield insisted that the legal profession was stuck in the past, using calcified business models that don't innovate to increase value and reduce costs, while 90% of the population was unable to obtain representation. The legal infrastructure we have is costly, complex, and unresponsive. Our business models for law throttle innovation. The problem is cost. Legal help is too expensive because of the conventional practice of law is extremely inefficient. It's not functioning well for anyone. This is really going to the heart of the practice of law, the way we do law in all its dimensions. And another speaker, and at the time, I'm not upgrading this to determine if people still hold these positions. As I said, this was from last year. A BC Court of Appeal Chief Justice Robert Bowman says that he's made access to justice a personal mission. It's something that I have focused on for 30 years myself. Quote, it speaks, I think, to a growing realization that access to justice is a very significant challenge for our profession and our communities, he said. It indicates that many are now acknowledging that the access to justice crisis is not one lawyers and justice professionals can ignore. The barriers to access will not magically dissolve. We need to act now. He said it would require a cultural shift in the profession and extensive collaboration in a big tent, replete with disruptors, innovators, and others who provoke and challenge with new ideas. It says, brick and mortar courthouses are jammed with frustrated self-represented litigants, bogged down in archaic processes, and lawyers blocking access to assistance with high fees and regulations that exasperate the crisis. Those earning big bucks in the profession are working for big business and couldn't care less. And the rest are scraping by pretending to be an elite, terrified of the public's screaming need for simplified proceedings, cheaper paralegals, do-it-yourself internet services, and other relief. Hadfield rubbed the profession's nose in its failures, and its emperor has no clothes stance. To give those in BC experiencing a significant legal problem only 1 hour of legal advice would cost $2.3 billion at the average billing rate of $300 an hour. It's higher than that now. Every practicing lawyer in BC would have to do 625 hours of pro bono work, 78 days at 8 hours a day, or nearly 3 months to meet that need, she calculated. There will never be enough government funding or charity to pay for that. Citing U.S. data, she said the top 20% of law firms get 80% of the business, primarily corporate work, and the other 80% chase what's left. Yet while demand for legal services skyrockets, law graduates and small firms struggle to find work. Hadfield said the economics of the practice of law needs to be changed. So for Indigenous nationals to expect to be able to hold their chief and counsel accountable by having to privately go to court, where they have no access to funds to do so, to hire lawyers. There will be no lawyers available to do this type of work because the income to be earned by lawyers will be earned by still the companies and by chief and counsel. The point of the Department of Justice in Canada fulfilling fiduciary duties of the Crown, becoming responsible for carrying those out, that was supposed to be the source of legal access to justice, of legal access. The lawyers, the Department of Justice lawyers, holding the Canadian government accountable and responding to protect the Indigenous nationals. That's not happening because the lawyers, and I'm not privy to the internals of it, but the lawyers are being controlled by government, basically. My understanding of it is not to interfere unless specifically asked for an opinion, which is, to my understanding, again, contrary to the responsibilities of Crown lawyers in the past. So we have Canada choking off the protections that Canada is bound to deliver, bound to protect the fiduciary duty, bound to protect those collective assets. Not doing that, squeezing communities in terms of not properly funding and equitably funding, even under the duty of fairness in terms of the amount of funding provided to Canadians, other Canadians. Remember, Canada deemed Indigenous nationals to also hold Canadian citizenship in 1960. With that came the duty of fairness to provide equitable services, as is done for other Canadians. So you have all that squeezed, and now you have Canada saying, Chief and Counsel, here's the solution. You capitulate, you become incorporated, we'll give you 10 years funding, we'll temporarily assist, you'll get all your trust account monies, and then what? What's really going to happen in a climate where we already have such a backlog of allegations that exist, where chiefs and councils, unfortunately, looking to protect their own families, looking to do whatever they can to enhance their own quality of life and those close to them. They then given access to multiple millions of dollars, and can we expect anything other than as has already happened in many situations in many communities, that those dollars disappear and there's no accounting for it. How are the people supposed to go to court to demand disclosure, of documents of what, to try to trace monies and to try to meet these allegations and prove these allegations of breach of fiduciary duty, for example? It's not going to happen. There's no one that is going to step forward. Look at me. I've spent, when I changed my path to fulfill the requirements of a lawyer to protect the people. When I changed my path, I gave up, 30 years ago billing at $500 an hour because of my particular expertise, that now I could bill, thousands of dollars per hour. Instead, I don't have an income. And I'm trying to educate and teach people and say, look, you can't rely on anyone to come forward to be there for you. You have yourselves and you have your power still. Don't hand it away. Don't hand it over to others, because you're not going to be able to protect what will happen and what will come for future generations. The highest probability is there will be nothing left. Many warnings that money is not all there is. And when money goes, it's pretty hard to trace it back and get it back. So I really want to emphasize, people, spend a lot of time researching past and looking at previous issues and in thinking, okay, we can go to court on this. Again, how? Do you have $1 million to run a lawsuit? What will it take from your community to fundraise, to do this stuff? And remember, you're going into a domestic court. What are the costs? What do you actually lose besides taking the critical dollars away from the community? You're actually going into a system and accepting that you're no longer sovereign, you're no longer a nation. What needs to happen is not these justice initiatives that are underway that deals with criminal law, for example, and sentencing and hearings and all that. What needs to happen is to establish a proper civil service for the nationals, people who are paid a good, decent salary, whose loyalties are not to chief and council, but their loyalties are to the people as a whole, the nationals of the whole. And once you have that check and balance in place, then you can look at how to better accommodate the sharing of dollars owed to the Indigenous nations. But this approach of community to community, all you're doing is creating a few wealthy individuals who are willing to give up, their people in exchange for that personal benefit. You're not going to get any decent initiatives happening until you're able to look at yourselves as a whole on that bigger basis and say, if Canada is not fulfilling obligations, if we can't, through these kinds of initiatives, if we can't force chief and council to live up to the obligations, what can we do? Well, you need to establish your central civil service of justice, your own access to a dedicated group of lawyers who can be prepared and know how to then go into court on specific issues without jeopardizing the aspects of nationhood and sovereignty, who are also able to trigger things like international arbitration, where it becomes matters of failed diplomacy regarding treaty matters. So, with respect, not ready, right? Canada says, oh, well, you got to do this first before you're ready to do things. Well, it's like, okay, you need to give up, become something else, destroy yourself before you can be reborn. What I'm talking about is enhancing your existing nationhood and creating for yourselves the checks and balances that are desperately needed without relieving the crown of her obligations. This is a body that will hold the crown accountable through her Canadian governments that are responsible to do and fulfill certain obligations by treaty. That's all I have to say.